Hello everyone, happy Monday. Jackie Broman here. Join Jackie's on Monday mornings. I do apologise I missed last week. It was just all a bit tricky with coming out of lockdowns and looking at what the week ahead was going to be. But I'm here today, and today I wanted to talk about when a will becomes invalid, primarily after a separation or divorce. So a will, if you do a will before you get married, then the marriage invalidates the will. There are a couple of exceptions, and that is if you put in the will that the will is done in contemplation of marriage, then the actual marriage won't invalidate the will. But for the majority of people, if you did a will and then you got married, your will prior to that is invalid because they assume that from marriage, or the law assumes, because remember this has been established over hundreds of years, the law assumed that your obligations change once you're married, and that any will you had prior to that is null and void. But what happens when you separate or divorce? So separation doesn't change your will. If you did a will while you were married and everything is left to your spouse and then you separate, the will is still valid and still stands. So it's probably a good idea to redo your will at that point if you separated. If you divorce, it also doesn't invalidate your will. However, what it does do is treat your spouse as if they were already dead, which is quite an interesting thing. So if your will left everything to your spouse and then you divorced, the will is read as if your spouse has died, and so whatever you have following on from that will be what's followed. A worst case scenario potentially is when someone has been married and has never done a will and then separates or divorces and dies without having had any will. If you die without having a will after you've separated or divorced, your spouse is still considered a spouse within a 5-year period of that separation. So the laws of intestacy changed in about 2015, 2016, and we now have a structure that says if you have multiple spouses, and that is in the last 5 years, not at the same time. So there's a number of people you've had as a spouse in the last 5 years before you die. They share what a spouse would ordinarily get, which can be quite difficult, and the law actually doesn't set much out for how to work out who gets what. So really just to bring to your attention when a will is valid or not. So a marriage invalidates a previous will, a divorce does not. The divorce just treats the ex-spouse as having died already, so your will is still valid, but it skips the spouse. But as I said, the even more important situation quite often is if you have separated and do not have a will at all. It is then really important to do it, because if you pass away intestate, that is without a will, your spouse will be the one who benefits, or ex-spouse. So there you go. Short and sweet on a Monday morning. I hope that is helpful. This video will be saved onto the page so that you can go back to it after it's been live. Please tag someone's name in it if it's relevant for them, or you can share it via Messenger if it's private. Otherwise, please let me know if there's any particular topics you want me to cover. You can contact us direct through our Facebook page or on our website. All our direct emails are listed there as well. Otherwise, I will see you again next Monday. I hope you have a great week. Starting to feel like spring a little bit. I know it'll probably be cold again before it gets warm, but I'm taking the sun while I can get it. So, see you next week.